We find that learned single judge, though has referred to the judgment cited by counsel for appellant corporation but has not considered the arguments raised in correct perspective in tune with the ratio laid down in the judgments cited staff. Court has recorded finding to the effect that court will not ordinarily interfere with such policy of fixing time limit unless it is ex facie arbitrary and unreasonable staff. In interview, maximum limit of 3 years, does not appear to be unreasonable considering objective of providing compassionate appointment. Hence, we do not find ourselves in argument with the view taken by learned single judge staff para. We have gone through the OM and find, when a candidate is not offered appointment, his name is carried forward for next year since quota is only 5% for compassionate appointment out of direct recruitment quota staff. A fresh review of financial status of family is taken and then again, for next year. Same exercise is repeated staff. We find it difficult to convince ourselves with any such analogy that such exercise should continue till appointment is given staff. There has to have some ceiling at some point of time, and we find that two reviews in case of a candidate are genuine, reasonable, and if a candidate's financial status is found to be sound or that he has been denied appointment due to non-availability of vacancy and has survived, then such candidate cannot be continued in the wait list for unlimited period or for longer than a reasonable period staff. What should be a reasonable period, it is for the department or employer to decide as a matter of policy staff. Considering entire policy of compassionate appointment in question, we do not find any such thing which may be said to be vesting a an arbitrary discretion's staff. Court normally does not interfere with a policy decision unless probably it is arbitrary to hold that ceiling limit of 3 years provided prescribed by department concerned is unreasonable or arbitrary is difficult to accept staff. Whether offer of appointment in the category of compassionate appointment shall be carried forward for 3 years or more is well within the domain of policy making body of concerned department corporation staff. Besides, we do not find circular policy in any manner irrational staff para. Even otherwise, it is well settled law that court shall not lightly interfere with any rule or law making process staff para. In Purushottam Govind Ji Halai versus Sri B.M. Desai, additional collector of Bombay and others, AIR 1956 SC 20 court held that duty of constitutional courts is not to suggest what law should be stopped. Court's duty is only to interpret law stop. Court referred to the authority of U.S. staff. Supreme Court in Middleton versus Texas Power and Light Company, within bracket 249 US 152, 157 bracket out code. There is a strong presumption that a legislature understands and correctly appreciates the needs of its people, that its laws are directed to problems made manifest by experience and that its discrimination are based upon adequate grounds. Stop.